While on the topic of consent, we shall now answer a question whether a consent obtained through a promise of marriage is vitiated if that promise is not fulfilled subsequently. The law on this point was laid down by the Supreme Court in 2003 in Uday versus State of Karnataka. This is the decision of the court. Consent given by the woman to sexual intercourse with a person with whom she is deeply in love on a promise that he would marry her on a later date cannot be said to be given under a misconception of fact. The prosecution point in this case was that the consent given by the woman was under a misconception of fact, and the misconception was the false promise of marriage, and therefore under section 90 first paragraph the consent got vitiated. The court ruled that in a case where the woman was deeply in love with the accused, the consent given on a promise to marry cannot be said to be given under a misconception of fact. A false promise is not a fact within the meaning of the code. It's an important proposition of law. A false promise is not a fact within the meaning of the code. She had sufficient intelligence to understand the significance and moral quality of the act she was consenting to. She freely exercised a choice between resistance and assent. There is no evidence to prove conclusively that the appellant never intended to marry her. This again is an important statement. The court has said that there is no evidence to prove conclusively that the appellant never intended to marry her. Perhaps he wanted to, but he was not able to gather enough courage to disclose his intention to his family members for fear of strong opposition from them. While deciding this case, the Supreme Court relied upon the Calcutta High Court judgment in Jayanti Rani Panda versus State of West Bengal. In that judgment, the Calcutta High Court said that failure to keep a promise at a future uncertain date due to reasons not very clear on the evidence does not always amount to a misconception of fact at the inception of the act itself. The ground in this case was also the same, that the consent was given under a misconception of fact. The Calcutta High Court observed that the fact alleged is a promise to marry we do not know when, and when a full-grown girl consents to the act of sexual intercourse on a promise of marriage and continues to indulge in such activity until she becomes pregnant, it is an act of promiscuity on her part and not an act induced by misconception of fact. Section 90 IPC cannot be called in aid in such a case to pardon the act of the girl and fasten the criminal liability on the other party, that is the accused, unless the court can be assured that from the very inception the accused never really intended to marry her. This last line is the crux of the matter. If it can be shown that from the very inception the accused has no intention to fulfill the promise, if it can be shown that from the very beginning the accused never intended to marry the woman whose consent he was obtaining by making this promise, then maybe it can be said that the consent was vitiated, but not otherwise. If it cannot be shown that the accused never really intended to marry the woman, then subsequent developments because of which the accused is not able to fulfill his promise cannot vitiate the consent which was given earlier. There are two exceptions to the provisions of Section 375. As per the first exception, a medical procedure or intervention shall not constitute rape. And as per the second exception, Sexual intercourse or sexual acts by a man with his own wife, the wife not being under 15 years of age, is not rape. There are two effects of this exception. First, where a man commits any of the sexual acts which are specified in clauses A to D of section 375 with his own wife, then any of these acts will not amount to rape even if he does not obtain the consent of his wife. So, the element of consent is not required where the sexual act is done by a man with his wife. That is the first effect of exception 2. Further, the general age of consent under section 375 is 18 years. Any sexual act with a woman who is under the age of 18 years will amount to rape regardless of the consent, which means even if the consent of the woman is available, it will still amount to rape if the age of the woman is under 18 years of age. But in terms of exception 2, if the sexual act is committed by a man with his wife, then it will not amount to rape even if the age of the wife is under 18 years of age. If the age of the wife is between 15 to 18, it will not amount to rape. If the age is under 15 years of age, then the benefit of exception 2 will not be available, and then the act will amount to rape regardless of the consent. It is extremely important for us to note at this stage that the provisions of exception 2 have been laid down or modified by the Supreme Court in 2017 in the case of Independent Thought versus Union of India. The issue before the Supreme Court in this case was whether sexual intercourse between a man and his wife being a girl between 15 to 18 years of age is rape. The court said that as per exception 2 to section 375 IPC, such a sexual intercourse is not a rape, but in the opinion of the court, sexual intercourse with a girl below 18 years of age is rape regardless of whether she is married or not. The court said that the exception carved out in the IPC creates an unnecessary and artificial distinction between a married girl child and an unmarried girl child and has no rational nexus with any unclear objective sought to be achieved. Which means this classification is in violation of Article 14 of the Constitution, which though permits reasonable classification, but there has to be a rational nexus with the classification and the objective which is sought to be achieved by that particular provision.